this house, the Boothroyd Room.
For the inquiry being conducted by the Intelligence and Security Committee. Can I welcome our witnesses this morning? This is the second of 7 public sessions that we're taking evidence during the course of this week and on other occasions with regard to the inquiry that the Intelligence and Security Committee have decided to conduct on the issues of privacy, security and matters related to that. We have taken evidence some time ago from the intelligence agencies. Tomorrow we will be taking evidence from the Home Secretary and subsequently from the Foreign Secretary and from other witnesses. So we're particularly grateful to you this morning for joining us, and we look forward to what we hope will be a good, lively and mutually instructive and beneficial discussion. Could I perhaps, for the benefit of people elsewhere in the room, invite you just very briefly to identify yourself, perhaps starting with Emma Carr.
Sorry, I'm Emma Carr, I'm the director of Big Brother Watch.
Thank you very much.
I'm Eric Metcalfe. I'm a barrister at Monkton Chambers. However, I'm here today representing the human rights organisation Justice.
Thank you.
I'm Isabella Sankey. I'm the Director of Policy at Liberty, the National Council for Civil
Thank you.
Liberties.
Hannah Stevens, the Interim Director of Rights Watch UK.
Grand. Thank you very, very much indeed. We hope this will be a relatively informal exchange. We have a range of questions to ask you. The primary purpose of this morning is for us to hear your views, so that can be a contribution to the work we are doing for the purpose of our inquiry. We have quite a lot of business to get through, and we only have an hour and a quarter to complete that. So if I could encourage both my own colleagues and witnesses to give succinct either questions or answers so that we can try and get through all the business that we would like to handle. Could I perhaps just begin by asking a question of our panel? It would be helpful, I think, for us. We've seen the written submissions which you've helpfully sent to us. Would any of you care to just give us an initial comment on this issue of privacy and security and the relationship between the two with regard to the issues that we are considering? Who would like to volunteer a view on that, on the general question of the relationship between privacy and security? We've suggested there needs to be a balance. Some have questioned whether balance is the right word. Please.
Happy to go first. I think balance can be unhelpful sometimes in this debate because I think it implies that the two are always working in opposition to one another. We actually believe that privacy is essential for security and vice versa. And the human rights framework provides that both must be protected as well. So I think the idea of sort of pitching the two concepts as a dichotomy is unhelpful. I think it also leaves out of the debate the many other rights and protections that government is responsible for. So privacy is essential for liberty, for freedom of conscience, for the many other human rights values that our nation has ascribed to for so long. So I think it narrows things and it unhelpfully sets the two in opposition.
That's very helpful. Could I just press you just a little bit further on that? Is there any question of an absolute right to privacy, or is it accepted that there are legitimate occasions in which the state or the government or whomsoever it might be is entitled, it's right and proper, to reduce some elements of privacy in the interests of the safety of the public or for other reasons of that kind?
Absolutely. The right to privacy is a qualified right, and it can be interfered with for a range of purposes, including for the protection of rights of others. Similarly, interestingly, the right to life is not an absolute right. The state is permitted to take life in exceptional circumstances. So describing either as absolute, I think, is misconceived as well.
Hazel?
I think you've covered my question.
Thank you very much. I'm sorry about that. Ming?
I'll just ask you about, I understand the intellectual criticism of the word balance, but these of course are two characteristics which have a relationship with each other. And it seems to me, and I'd be grateful to know whether you accept this or not, in a time of relative peace, then the balance between privacy and security, forgive me using the word, might well tend towards privacy. In the time of relative danger, when the interests of the country and indeed the safety of the citizens are at stake, the emphasis may be on security. How should we determine where the emphasis is to be put at any particular point? Because this, in the end, is a responsibility of government. Is it enough that the government should have to make these decisions? Well,
I think with respect,
that's also a very dangerous beginning to any question.
I would say that it's unhelpful to deal with questions such as privacy versus security in general and abstract terms. To suppose that a balance can be struck in general terms for the sake of a general situation. I think you always have to look at the specifics, you have to look at the context, you have to look at the particular measure that's being proposed, and you have to say, how is it justified, not only by the particular circumstances such as a threat, a specific threat, or a more general threat of post 9/11 security concerns, but also what is the aim that you are pursuing, generally national security and the prevention of serious crime. What is that aim necessary, and is the restriction that you're proposing in this particular case proportionate? And that is, I think, a much more particularised question, and I think that to talk and I agree with everything that Bella has said, but to talk in general terms about, well, this is we're under threat now, so we need more privacy and more security and less privacy, it doesn't really assist.
Well, please go on.
Just a more general point, just to add on to something which Bella has said. I think it's important to bear in mind that the right to privacy is not just an individual right, but also a public good. It's something which exists not only for my own benefit, but also for all our benefits. That society as a whole is better when each of us have our right to privacy respected. And that is true not just when times are good, but also when times are tough. And in fact, I would go so far as to say it's especially true when times are tough. It's even more important in times of crisis and times of threat that we remember what our fundamental rights are.
But, you use the word context, which I thought was very interesting. If the context is, I think that we don't have the threat up here at the moment, but if the threat, which is on these television screens, is enhanced, does that make a difference or not?
Can I think what we're defining as national security and threat is extremely broad. I think if you ask any member of the public if you support the intelligence agencies or law enforcement to have the tools to tackle national security, everyone would agree with that. But I think national security as a definition has become extremely broad, and I think we've seen that with the development of RIPA since 2000. I think we all agree that it was initially brought in to tackle elements of national security, but now it's being used. And when we've applied for information through freedom of information, or when we've requested information on why certain tools like RIPA are being used, it's being defined in the terms of national security. And I think when they were first defined, it certainly wouldn't have been there.
George?
Thank you.
I wonder if it would be helpful if we could look at a specific case, a known case, and work out at what point there is a concern about it. I'm talking about the case of Rashanara Chowdhury, who stabbed Stephen Timms at a surgery. Her radicalisation took place entirely online, and it started off with looking at various sermons which gave a particular Salafist view of Islam. That presumably is okay and off limits. The second phase of it was to get in touch with organisations online who were promoting jihadist activity. Again, that might be acceptable. Finally, though, she got linked into the online magazine Inspire, which gives specific instruction in how to construct a bomb, etc. At what point in that spectrum do you think the state has a legitimate interest in intervening?
Liberty doesn't take any issue with the idea that when an individual gives cause for suspicion that they are planning some criminal activity, whether that's terrorism or, to be quite honest, other forms of crime, that they shouldn't then be subjected to targeted surveillance. But the reason why I think this inquiry has been convened in response to the disclosures that we had last year is not because the state is engaged in only looking at the communications of individuals who are considered to pose a threat, but because it's currently engaged in looking at millions of more communications. So on the issue of targeted surveillance, we're getting into specifics. If somebody gives cause for concern, then fine, but RIPA, as Emma has already referred to, doesn't require reasonable suspicion or any link to criminality before its powers can be exercised, and it contains huge numbers of loopholes, which we now understand has allowed our security services to surveil, to intercept, and to acquire communications data on a scale never previously imagined. Okay. And this has been something that's come about in the last couple of years without public, or we understand, significant parliamentary understanding or approval.
Thank you. Your answer has actually taken us into what was going to be our next area of questioning. Julian, this is on the question of targeted intrusion. Julian, we can probably be pretty brief, but if you could help us on that.
You've taken this forward extremely well, because I assure you, you have our solemn promise we will get into this whole question of the bulk monitoring. But in order to nail things down, is there anybody on the panel who disagrees then with the proposition that where there is specific intelligence that an individual poses a direct threat to the United Kingdom, that it is proportionate and that it is appropriate for the agencies to investigate that individual, and for that investigation obviously to intrude on the individual's privacy? You've already given your answer, Isabella. Does anyone disagree with the answer we've already had from Isabella?
Actually, I would. I think, in fairness to Mr. Sankey, that the way in which you phrase the question can, and I'm sorry for being legalistic, but this is my daily bread and butter, can give rise to some slippage. The specific test is whether specific powers can be used in relation to that individual. You've referred to direct intelligence that the person is a threat, but you would of course have to assess the quality of the intelligence, because intelligence can be of extremely high quality or extremely low quality. And merely to have some intelligence that a person was a direct threat would not be itself would not itself justify the use of intrusive
I'm afraid
power.
that the terminology I used said specific intelligence, and I think that is a clear enough suggestion. Obviously, you have to make judgments in each and every case, but we're not going to get very far if we're going to get to that level of nitpicking. The reality is that the position that you seem to be taking, unless anyone disagrees, is that where there is grounds for reasonable suspicion that someone ought to be investigated, it is appropriate for that person's privacy to be compromised by an investigation. Is that right or wrong?
I would agree that it can be the trigger for more intrusive powers to be used.
I'll take that as a yes, but we do only have limited time, so a little more directness would be appreciated.
Thank you. If I may just add, in the example you used about Chowdhury, they would inevitably throw up the surveillance monitoring analysis of telephone evidence. Names, colleagues, associates, friends of that person that were entirely innocent. So there's also a responsibility to act appropriately in relation to superfluous or irrelevant data, and that is also important to remember, the accountability and oversight that I'm sure we'll come to in due course. I don't wish to intrude.
Thank you. Can we, during Mark, a point you'd like to make?
Obviously, we're living in a fast-changing world because of technological advances over the last decade or so, and who knows the pace at which that will continue, and we all appreciate that that must have a bearing on ensuring that we have legislation that is workable. And arguably, in the last 14 years since RIPA, we've now got what is, to a large extent, fairly defunct legislation. Do you think that the monitoring of an individual's internet communications is therefore more intrusive than the more traditional types of surveillance and intrusion that were there in a bygone era of sort of opening people's mail or tapping their telephones? And if so, why do you think that this is more intrusive and therefore something that you have a closer eye on today than you would have had a couple of decades ago?
I don't know that it has to be more intrusive. It simply has to be as intrusive. It is as intrusive as opening your mail. It is as intrusive as listening to your telephone conversations. I think, to an extent, you should take it more seriously now because we spend far more of our lives online now than we did 14 years ago. Some people were online quite a lot 14 years ago, but most people weren't. Yeah. Now, most of our transactions are handled online. Most of our private relationships are conducted in some way each day via the internet or via fibre optic cables, what have you. The infrastructure of the internet is basically carrying, in the course of doing so, recording every aspect of our daily lives.
I just wonder, sorry, I'd like others to have to say as well, but also, is there not an issue of implied consent? So quite a lot of what you do online, the idea of buying products online, you kind of know, well, my past record of sales and purchases will be picked up and that will be fed through. That there's more of an implied consent by people using the internet on a day-to-day basis in a way that, as I say, some of these past techniques, there was clearly...
My consent is entirely, with respect, one-to-one. If I buy a book from Amazon, I expect Amazon to be bound by its duties under the Data Protection Act to secure my data. Just as if when I give my letter to Royal Mail, I expect Royal Mail not to open my mail and tell their neighbour what I'm up to. The same goes absolutely for Amazon. And there's no more implied consent in me ordering a book from Amazon online than as if I were to do so 30 years ago through the post from my local bookshop. I have the same right to the integrity of my communications.
Just because you choose to do something online doesn't mean that your expectation of privacy should diminish. Just as you go into a bookshop to buy a book, you don't impliedly consent to somebody sent from GCHQ to be standing by the till making a note of the fact that you've bought
no, but
that
somebody
book.
from Waterson's might well send you details in a few months' time because of the book you bought, of similar sorts of...
I think the important point here is about rate of analysis and ease of analysis. If you're looking at internet communications, it's very easy to look for a name or specific information and to look for everything that corresponds with that and analyse it. To do that to post or CCTV or footage and things like that is a lot harder to analyse, and so that's where I think the difference in intrusion comes in.
Just to clarify, I don't mean it seems to be difficult in relation to all your questions. I would concede that there are parts of the internet that are entirely public, and it is legitimate for that material to be expected. If I go on Twitter, am I broadcasting my opinions to the world? I can hardly complain if someone takes note of those opinions and then later on uses that information against me. But I think you have to be very careful. You always have to, as I say before, look at the particular case. You have to look at, just because I put a post on a friend's Facebook page doesn't mean that I've lost the expectation of privacy vis-a-vis my friend.
And similarly, just the expectation of privacy doesn't mean that the internet should be an unpoliced place. Just as Eric says, there are public spaces on the internet, but even in those private spaces, when you are talking about emails and messages being sent over the internet, that the expectation of privacy should absolutely remain, but that doesn't mean that in the circumstances that we've just heard described, that cannot be compromised when somebody gives rise to suspicious activity.
That's the very specific thing. If you as an individual, I think any decent member of the public would suspect, if you write something online and you're suspected of a crime, there are ways and means of law enforcement to go and access those communications, and everybody understands that. If you're not suspected of anything, I think that's where the line comes in of having the right to privacy online. And I think that's whether online or offline.
Thank you. Robin, if you'd like to round up this area.
Just one question on this. Are you concerned about non-state intrusions of privacy as well as state intrusions of privacy?
Yes,
you all are.
I think there's a difference between state and non-state actors in principle terms, because state actors have very coercive powers over individuals, the ability to prosecute, put on trial, in our country, take away somebody's liberty, in other countries put them to death or other similar punishments. So there are principal distinctions, but it seems that the lines have become so blurred between the activities of non-state actors and state actors that the concerns we have about state actors certainly equally apply to non-state actors.
And that goes back to a point which I made before about my rights vis-a-vis Amazon, for example. Yeah. It's interesting that now in 2014, as much of the regulation of what we might consider as being traditional surveillance, which is gathering information about people for whatever purpose, including the detection of crime, is governed in large part by data protection as much as REPA. So data protection framework is now, in a way, a large way in which we regulate the way in which data can be collected, retained, used, and so on.
Okay, well now,
State versus non-state.
sorry, I beg your pardon.
Forgive me, the state is under a different duty to not just protect our national security but also our privacy. So obviously non-state actors have a different, private companies are not under the same duties, and we have higher expectations, arguably, of the state in relation to our individual rights.
Thank you. Now, I want to come on to whether there are particular people who deserve special protection. I mean, I think we'd all agree that intrusion must be proportionate. In other words, it is more justified if the suspicion is more serious, of more serious crime. But are there categories of people who deserve a higher bar to be set? And I'm thinking of lawyers, religious figures, doctors, or journalists. Do you think any distinction needs to be made on that spectrum of the type of people who may be targets of intrusion?
I think it's more important to look at the function rather than the category. I don't have greater right to privacy because I'm a barrister than someone who is not a barrister. I do, however, in relation to the specific work that I do, my day-to-day functions as a barrister, when I'm giving legal advice and so on, have greater protection. And that's not only for my own benefit, it's more for my client's benefit, but also for the court's benefit, for the public's benefit, because we recognise that there's an importance to people having the right to receive confidential legal advice as to their affairs.
I think it's very important, but I think it's also somewhat arbitrary. And a lot of the times when you're seeing potential misuse of these surveillance powers, it's because they're being overused and they're not being overseen properly. There's the lack of accountability and transparency of how they're being used, and I think that's very much being put in the public domain about the police use of Ripper and journalist records as well. I think that's because of a lack of understanding from police forces themselves of how Ripper is supposed to be overseen, and the authorization process, and also the public knowledge about how easy or how accessible communications data is via police.
Namely, I think you wanted to make a brief question.
Back to the question of state and non-state actors. Do I understand you that if my purchasing pattern becomes known to Tesco, then is that something which deserves the same protection as, for example, my blood group or the people I associate with? And if so, how do we enforce that? Not least because there appears to be some trade in that kind of information.
You enforce it through the data protection framework. And the data protection framework stops Tesco's, in principle, selling that information to a third party without your consent. One of the difficulties in the modern day and age is that we all sign up to various services and don't look closely at the fine print. We don't realise, most often there's, do you agree to the terms and conditions, tick the box. And one of the conditions will be, Tesco or whoever else may use this information, may sell it on to other third parties for the use of various services.
But ultimately, companies are a creature of statute and can be regulated by states and by parliaments. And just as, in our view, the security services have overreached when it comes to their privacy infringements, so too it may be the case that private companies have, and regulation hasn't kept up.
To address a specific point, my purchasing history is sensitive. It's private information about me in the same way as my medical information. In fact, you can probably tell quite a lot about my medical status or what I am doing in my private life from looking at my credit card record.
That's how you link up all of that information. Your loyalty card data from a supermarket might in itself be useful to that supermarket, but then if you link it up, say, with your medical records, which I think at one point was actually a policy suggestion, to see whether people are buying 4 pizzas a week and then they're not going to the gym, so you also need your gym membership data to see how often you've gone to the gym to get a more accurate picture. So in itself, those things by them aren't particularly intrusive, but build a bigger picture, and we have it there. And it's available, then it becomes far more intrusive.
I think that's been a very, very helpful discussion. I think it's now time to move to one of the very core issues that we would like to hear your views on this morning. I think there's been broad agreement that when people are a threat to the safety of other citizens, it's right for the agencies to be able to take action to find out what they're up to. So we come to the question of how they can do that. And part of this debate is, should they have access to what is often referred to as bulk interception in order to identify who might be a threat to the public safety? So Michael Lothian, would you like to...
ask my question?
Well, no.
To start
I
with.
didn't intend to, but would you like to expand on the question?
Yes, I mean, this is really just sort of beginning to open the debate on bulk collection. Certain categories, certainly, of threats to our society, terrorists, criminals, go to great lengths to conceal their identities and conceal what they're doing. And therefore, I think it's presumably acceptable that the state has the means to try and find out who those people are. And to do that, they obviously have to go beyond what we've been talking about in terms of targeted technique. Would you accept that the state has the right to collect communications in order to try and establish the unknown fact until then of who is intended to do what, which could be a danger to our society?
I think that mass and indiscriminate surveillance does threaten citizens' fundamental rights, and these rights can't be circumvented or traded off against any perceived benefit in exchange unless that's set in an adequate legal framework and is in full compliance with that framework. And we're not currently enjoying that position today, with REPA being so outdated and
I think
the categories being...
we'll come on to the framework, I think, a little later on. I'm trying to establish the principle as to whether you accept that in order, for instance, to find out what terrorists are plotting, you may have to go beyond targeted techniques and actually be able to collect information in order to try and find out what's going on.
I think, again, the problem is the way in which you talk about collection. You move from targeting doesn't work, so we need collection or beyond targeting in order to address the problem. But let me put it this way.
I'm not saying targeting doesn't work. I'm saying in order to get to targeted, you may have to collect information to decide who you're going to target.
Well,
I'm asking, do you accept?
Then allow me to address it that way. My point is that your collection would also have to be targeted. You cannot just simply say because the targeted approach under Section 8.1 of REPA, which is particular persons or premises, doesn't work because you can't identify the particular person that you are looking for, then ergo bulk collection on an indiscriminate basis is therefore justified. It's a false premise. What you have to do in that situation, if you are trying to identify a person unknown, a John Doe, as it were, who is involved in very serious terrorist activity, then your collection of the premise of the need to collect data of communications unknown also has to be targeted. So say you know that the person unknown is visiting this particular site. You don't know other things about them, but you know that they visit this particular site on this particular time. It would be reasonable in that circumstance, or proportionate in that circumstance, to collect communications of a particular group of individuals or category of individuals visiting that particular site at a particular time of day, so long as that group was not so large. If it was like 5 people a day visit this particular website, then it might be proportionate. It might be proportionate in those circumstances to collect the information of 5 people. What we are seeing, what we have has been disclosed from the Snowden revelations and so forth, on the other hand, is an entirely different category. You are talking, if the reports of Tempora are true, and you are in far better position to know than any member of the public, if they are true, then what we are seeing is a 30-day rolling buffer of all communications going across fibre optic cables, and all communications data being retained, for which there is no safeguard under Section 16 of REPA. And that is profoundly concerning. It's, in crude terms, the largest breach of privacy in British history.
Can I interject? I think with all of these things, it's the last decade, every policy solution has been to collect more data. And that's usually because there's a feeling that traditional methods have failed. And actually, from my perspective, it's because traditional methods have failed to keep up with either the rate of investigation or the rate of technology. And so you just need to look at kind of recent examples. So the NSPCC released an FOI last week showing that there was hundreds and hundreds of pieces of hardware sitting in police forces because they didn't have enough digital forensic experts to go through and look at them. Clearly, that's not acceptable. You've got the Julian Hupper case that was raised in the Commons yesterday that the Home Secretary responded to, where CIOP had failed to react to 2,500 names of potential paedophiles. Again, that's not an acceptable place to be, and it's because of a lack of technical ability within traditional police forces and awareness within traditional police forces. So it wasn't, in any of those cases, it wasn't because they didn't have the data there, it's because they didn't have enough capability to deal with it. And I think that's a huge problem that we need to face, and we haven't done that yet.
Hazel, would you like to come in?
Yeah, I just want to follow up some of the points that witnesses have made about I think the phrase was indiscriminate surveillance, which is a major concern. And obviously the analogy has been drawn that if you want to develop targets, you don't have information about specific individuals. If you want to develop targets, then you have to have the pool of information in order to be able to target it. Now, I don't know whether you have an objection in principle to the collection of bulk data, or whether your objection is to the interrogation of that bulk data. Because if it's simply the collection that you have an objection to in principle, then you would be limiting the possibility of the agencies in developing targets for future examination. And I'm just quite keen to get your view on whether or not you object to bulk collection per se, or whether your concern is about bulk interrogation of that data. And obviously, if you're going to interrogate the data, you have to do it with a targeted search, you have selectors, you have filters, so there are ways in which that bulk collection can be subject to targeted interrogation, which is covered by a legal framework. And I don't know whether you object to the bulk collection or whether you object to the interrogation of that collection without proper safeguards.
The objection is to both the collection and the interrogation without an appropriate framework. There is nothing passive about GCHQ collecting millions and millions of communications of people in this country, indeed having the power to collect all communications outside of this country because it falls within the external communications definition, even if they are not processing those, or even if human beings are not processing those and it's being done by machines. That is a physical interception. That is a privacy infringement. And it's something that we've not traditionally, it's a model we've not traditionally followed in this country, you have blanket interception.
I understand that, and I think it's important that we get this on the record, that your objection is to the bulk collection in the first place, but would you accept that in order to develop targets, people that we don't know yet, that we don't have reasonable suspicion about, how are you going to gain that information unless you have the pool of information in the first place that can then be subject to interrogation?
The concept of the pool here is the way in which the concept of bulk slips in, because the supposition seems to be that as soon as you are unable to identify a particular individual, then you can throw the net as wide as you like, which can't be true. I mean, the idea that collection itself is not an interference is again, with respect, absurd. Imagine if you took my diary and said, don't worry, we're not going to read this unless we get a warrant from the Home Secretary. Or you could easily turn it around and say, let's put a CCTV camera into everyone's bedroom in the country, but we won't be able to turn that CCTV camera on until we have an authorization from a judge. The very act of collection is itself the intrusion on privacy in many ways, whether or not it is ever looked at. We can look at the situation in 2008 when Liberty won its case before the European Court of Human Rights. Collecting the DNA, the intimate genetic information of individuals who had not been charged or convicted of any criminal offence, was held to be a fundamental breach of their right to privacy. The same is true if you take my letters, if you take my diary, if you take footage of my house, even if you never look at it. There's an interference in my privacy. Part of it comes from the uncertainty. I can't ever know for certain whether you've looked at it or not.
Okay. So if that brings us back to, if you like, the I won't call it a balance because I don't think that's the right definition. You've got a right to privacy and it's subject to constraints through legal authorization as to where we are. But what you're actually saying is that you think that the bulk collection is a step too far in terms of infringement of privacy, and therefore if you're unable to analyse targets and develop targets that subsequently would contribute to national security, that you are prepared to forego that possibility because of the intrusion into people's privacy. Your balance falls in not having bulk collection at all.
Absolutely, and there are many ways in which the security agencies have abilities and powers to trace suspicious activity without having a bulk of information on the scale that we've seen. we understand it's something that's actually only come about over the last few years, and it was a policy change immediately after 9/11 that led to the idea of this bulk collection. The reviews that have been conducted as to trying to investigate whether bulk collection has reaped the security benefits that the agencies claim have all concluded that indeed that analysis is flawed. The Obama White House appointed review group found that the NSA's program of bulk interception and metadata acquisition was not essential to preventing attacks, and that information needed to disrupt terrorist plots could readily have been obtained in a timely manner using conventional court orders and traditional investigative measures.
If there were evidence that the ability to have bulk collection and then to interrogate it through targeted searches that are properly authorised under a legal framework, if there were evidence that that technique and capability had helped to develop targets, to prevent plots, to contribute to national security, would your view be different?
No. Because that comes down to what kind of society do you want to live in? Do you want to live in a society where a framework and an institutional capability has been set up which fundamentally alters the relationship between the individual and the state in a way that we have never considered doing in Britain? Or do you want to live in a society where there is proportionate surveillance?
No, I understand that, and I'm grateful for your clarity on that issue.
Thank you. Julian Lewis.
Yes, it has been very clear, and I just want to put one point to you, which is that the people who defend the pool are categoric in their denials that they don't go fishing at random, that they do specific searches. And I want to come back to the very helpful example, Dr. Metcalf, that you gave when you said you think it's okay that if you to do a targeted search, that if you know that somebody that you wish to identify has visited a certain website, providing that there were not a mass of visitors to that website, it would be okay to do a targeted search of who had visited that website in order to narrow down the list of suspects. Now, without getting too tied up in the individual specifics of that example, that seems to suggest to me that you must have some sort of pool, as it were, or mass basis of data as to who is visiting websites, for example, in order to make that targeted search. How do you reconcile that example that you yourself gave of a justified search with your very clear collective view that there is no justification for having the pool in the first place?
Well, let me point to REPA itself. Section 8.1 allows you to target a particular communications of a particular person or a particular premises. Now, very often you're not going to know the particular person who's involved in, say, serious organised crime or drug trafficking or whatever. So you're going to start with, you have suspicion that a particular location is being used. So, 21.
Yeah, but can't we stick to the example of the website?
Well, no, because I think the premises example actually illustrates what I'm talking about, because you don't know the identity of the people involved, and there may be, in fact, entirely likely to be innocent people who are collaterally and caught up in your interception of communication in the premises. So REPA already allows for collecting the collateral interference with people's privacy, because you have suspicion against a particular location being used, but not the particular individual, and that targeting the premises will allow you to identify the individual. And once you have targeted the individuals concerned, then you will be able to have a more target.
That's taking it right away from the helpful example you gave before, because this business about bulk collection is mainly about bulk collection of data online and so forth. And you gave an example where it would be justified, in your view, to home in on a particular website and all the people who'd visited it. And yet, if you do not have the bulk data collected, you can't possibly do that. At least you certainly can't do it retrospectively, can you?
Well, why can't you get a targeted warrant in respect to the particular website that you are?
Okay, so in that case, you'd only be able to look at it in the future you wouldn't have any ability to go back and see who had been visited.
Well, with respect.
Well, I don't need the respect. I need the answer.
Well, it would be very nice for all investigators to have a time machine, but the idea that you should collect private information about individuals at a point when you have no suspicion that they're involved in any crime.
So, in other words, you can only go forward. You can't have the ability to go back and see who visited that website in the past. That's what you're saying.
Just as the same way that you cannot bug a person's car retrospectively, you cannot intercept their conversation retrospectively.
And it's also false to say that you cannot. Once you have established suspicion, if you have available records, you can, in a certain sense, of course, you make a request under Chapter 2 of Part 1 for the communications data in respect of that. But I think what you are leading to is a more general question, which was addressed by the Court of Justice of the European Union and Digital Rights Ireland in April this year, which is that you simply can't justify retaining the communications data of the entire population of the European Union for a period of up to 2 years, simply because of the suspicion that some of them might commit crime and be involved in terrorism, and that therefore it's going to be valued to go back.
But your view is that if you're going to target an online database, it basically starts from the moment you have identified it. You have to go without the potential resource of seeing who has visited it in the past, unless there is some sort of other record that can be accessed by specific application.
You have to have the suspicion before you can get the targeting.
Thank you.
The targeting cannot precede the suspicion.
Thank you. Mark Field?
I'm very candid about this whole thing, and I would probably share some of the scepticism that you would have about the security services saying we desperately need all of this, and the way in which we've thwarted attacks since 7/7 has been because of these powers. But let me just put it this way. Is there not a concern that if you have the ideal world that you've discussed, that we aren't allowed to have bulk data, that actually we will return to some more traditional means that may end up being considerably more intrusive, particularly with a heightened terror threat, that may undermine some of those planks of the sort of society that all of us want to live in, if we start having some more old-fashioned surveillance techniques being used particularly on parts of the UK community in a much more aggressive way, that actually may undermine what you're doing. And the argument that could be made is that in many ways the bulk collection, even if much of that data is never used, and there is neither the capability or perhaps even the capacity to be able to deal with anything other than a small proportion of that, which will only come to light when there are particular individuals who are being suspected of terror activity or paedophilia or other crimes. But actually the worry is if we step back from this and essentially draw a line and say we're going to do nothing whatever in the internet age and go back to old techniques, that actually we will have a very different and a much more intrusive society going forward.
You have incredibly powerful techniques. The intelligence services and the police have incredibly powerful intrusive techniques right now, which are entirely legitimate. What we are talking about is going a step further beyond targeting to bulk collection, and I don't accept that we have to allow for bulk collection because the alternative may be even worse. The alternative, if the alternative always has to be measured by reference to protection for fundamental rights, and if the alternative is equally bad, then it's equally bad. It's not a justification for bulk collection.
Can I, before we move on from this subject, can I just ask you to clarify what I think has been perhaps one of the most important pieces of evidence you've given to us. You expressed your belief that bulk interception does not in practice produce any substantial benefits, and I accept that that's what you believe, and that's on the basis of what you've expressed. However, you were asked if that was not the case, if there was hard evidence that bulk interception had produced significant material that had led to terrorists being apprehended or prevented from carrying out their deeds, whether you would still be opposed to bulk interception. And I just want you to clarify, because each of you said, as far as I'm aware, that even if that could be demonstrated, you believed that on the proportionality argument, it was still unacceptable for the intelligence agencies to have access to bulk interception. I want to be clear that we've understood that to be your position, so this is an opportunity for you either to say yes it is, or to qualify it in a way you think appropriate.
As far as I'm concerned, there's been nothing that's been shown within the United Kingdom to show it for millions.
That's not the question. Forgive me.
So it is. There's been,
I'm saying if evidence did emerge.
We haven't been presented with every time within the United Kingdom or the United States where it's been.
I'm not asking you. Forgive me.
You're asking us. You're saying if we are asked to believe some evidence that's been presented to us, but every time we have been asked to do that, it's been shown to be incorrect or not as effective as we have been asked.
No,
so we haven't been asked.
No, sorry, hold on. Let me ask the question, and then please try and answer the question you've been asked. The question is a quite simple one. We're not asking you to accept that there might be occasions when this did happen. I'm asking you a question of principle. It's a matter of principle. Let me finish my question, then please you'll have the opportunity to answer it. As a matter of principle, if evidence emerged which even you acknowledged through bulk interception had led to terrorists being arrested or prevented from carrying out their objectives, are you saying as a matter of principle you believe so strongly that bulk interception is unacceptable in a free society that even in such circumstances you would say that is a price we should be willing to pay rather than allow intelligence agencies to use bulk interception methods?
Yes.
Yes.
No, please, either say yes, that is your position,
you would, just as you would solve a lot more crimes if you had CCTV within everyone's house, just as you would solve a lot more crimes if you opened up everyone's mail and everyone's email and read it on a daily basis. You would solve a lot more crimes and you would have a lot more terrorists in jail, and that would be a good thing. But it would also be bad for our society as a whole.
And that is the view of your three colleagues as well?
Yes.
Right, that's helpful. We can move on now. Yeah, please, Robin.
Could you just explain to me, I mean, if you have bulk interception and indicators throw up 0.0001% of things that are suspicious, why doesn't that satisfy your definition of a targeted search?
Because you've already intercepted people's correspondence. So the analogy is that in the 1980s or 1990s, we suddenly decided to start taking copies of everybody's mail that was travelling through Royal Mail, just taking a copy in case in future we can run some new advanced technology on this and work out if there is any suspicious activity that we want to follow up. People would have known, if you take in a sort of traditional example of communication like that, that is unacceptable. It's just because it's easier to do because of the digital revolution and it's cheaper to do, doesn't mean that it's okay to do and doesn't mean it's the thing that we should be doing.
Despite the fact that it hasn't been looked at by any human actor.
Absolutely, because you've built the physical infrastructure to allow probably the worst type of oppression in future. And in any free society, it's not just about saying, take it on trust, we're not going to use it in this way, we're just letting the machines do it. It's about examining what physical infrastructure you're building, what the relationship is between the individual and the state. And not just expecting citizens to take it on trust and to accept the fact that not much of the material is currently looked at.
Final question in this area, George.
Yeah, there is an argument that because the collection of bulk data is, I think you've all agreed, in principle wrong, that there shouldn't be any collection of bulk data, and even though that might result, I mean, it's difficult to prove, but let's just say theoretically that in neglecting to do so, a horrific event took place, a horrific terrorist activity took place. And the argument goes that the intervention in privacy is so great that it's worth taking the risk, even bearing a small number of incidents, rather than breach that principle. Would you agree with that argument?
You can always build hypotheticals to justify any breach of fundamental rights, no matter how much. You can always say, yes, the right to liberty is really important, but if it would save 1 million lives tomorrow, would we do away with it today?
No, but this isn't hypothetical. This is about something that is already going on. This is about this is about data that exists, may or may not be exploited, and you object to that in principle, which is fair enough. But do you accept the corollary to that, that some things might happen that otherwise might have been prevented.
Absolutely.
Yes, and that's always the case in a free society. Some things might happen that could have been prevented if you took all the most oppressive and restrictive measures and privacy-infringing measures. But that is the price you pay to live in a free society. But I think one of the problems with answering these sort of hypothetical questions put this way is that all the current resource that has been going into bulk collection and the manpower and the money spent on that is necessarily money not being spent on other forms of investigation. So I think it's almost impossible to answer the question that, but for this bulk collection, we wouldn't have been led to X suspect or Y suspect, because you're all the time dealing with, a hypothetical and resource that hasn't been used in another area.
Thank you very, very much. I think we must now move on to... Sorry, did you make just a final comment, please?
If I may, I'll keep it short. In relation to bulk data, I think we should try to dwell on what is actually going on rather than the various different scenarios. And in fact, it is being collected, it isn't being well regulated. And that is the concern. There must be more scrutiny of this and more resources put into the oversight of those who are doing the surveillance. So I think there's some merit, obviously, in dwelling on the rights and wrongs of bulk data, but let's get back to the reality of the fact it's happening and it needs far better regulation.
Well, that will be part of our, if we have the time, that's what we will want to cover as well. You've been very, very frank in your answers, and we're very grateful to you for that. Can we now move to the question of the actual legislation itself that exists and whether there's a need to reconsider whether it's appropriate? RIPA has been described as an analog law in a digital age. I think each of your organisations has indicated a need to reform RIPA, but could you perhaps this morning give us some examples of the kind of changes to the legislation, not just should it be reformed, but what is the kind of changes to the legislation that you yourselves would wish to recommend that we should endorse?
Well, I think a first important safeguard is judicial authorization for all intrusive surveillance under RIPA. You have a patchwork system at the moment where different bodies are responsible for authorizing different kinds of surveillance. Some internal, some by a Secretary of State and some by a judge. And it's a highly unsatisfactory framework. So interception, on a traditional view, the most intrusive form of communication surveillance, is authorised by a Secretary of State. If, however, the police want to plant a listening device in my house or in my car, they get an authorisation from a surveillance commissioner who is a retired judge. Then, if someone wants to access my communications data under Chapter 2 of Part 1 of RIPA, let's say it's the Metropolitan Police, they don't go to a judge, they don't go to the Secretary of State, they go to a senior designated person within their organisation and get authorisation from them.
I mean, the principle behind that, rightly or wrongly, has been that the greater the degree of invasion of privacy, the higher the level of authorisation should be required.
Well,
now, don't you accept that as at least a reasonable principle, even if the way in which it's being applied may not be satisfactory?
I see the principle, although I would query whether you have, again with respect, a Secretary of State is a higher form of authorisation than a judge. A judge is independent and impartial. Secretary of State, however diligent and conscientious, always represents the views of his or her department and is accountable
Thank
to
you.
Parliament.
Fiona McTaggart?
Secretary of State was allowed to report to Parliament on this issue, and Parliament is accountable to the people. Would that change your view of this? Would the Secretary of State's accountability, which of course a judge is not?
Well, it would be very interesting to see a politician to be accountable for his or her surveillance decisions. But I suspect that is not appropriate for exactly the same way that search warrants authorised by Secretary of States have not been thought appropriate in this country for some 400 years. We would consider it intolerable, and indeed it was 400 years ago thought intolerable, that the Secretary of State, the Home Secretary of his day, was able to authorise general warrants in respect of people's correspondence. And that was struck down by our courts, and for 400 years that's been settled law in our country. So there's something extraordinary about the situation in which the Secretary of State can authorise intrusion into my private communications, my phone calls, but you need a judge to get a search warrant of a person's house. It seems to me that the judge should be in the same position. There's an argument to be had about the type of judge, I agree.
Is your argument, again, one of principle, or are you suggesting the Secretary of State does not apply the same amount of time and detailed consideration?
It's not the time or the consideration, and I'm fully willing to allow that the Secretary of State devotes a lot of time. It's not that they are slapdash or rubber stamping. It's simply that they are institutionally ill-placed to make the balance the fundamental rights of the public interest on the one hand and the rights of the individual on the other hand, which are also in the public interest, I might add, in this kind of situation. Because at the end of it, to give you a very brief example, after 9/11, the Home Secretary is undoubtedly going to be under, you heard from former Home Secretary David Blunkett yesterday, was undoubtedly under tremendous pressure to prevent attacks in the United Kingdom. It is very easy in that situation. The Home Secretary is accountable to the public for their protection. It's very easy to see that a politician in that situation might say, well, yes, this is going to interfere with the privacy rights of innocent people, but I think on the ballot box they're going to judge me more by the number of people who I say.
Have not, for example, the FISA courts in the United States been subject to exactly the same criticism of bowing to the will of the executive?
That's a judgment made by a judge. Now, I can address the FISA courts in more detail, but that's a slightly different context. The point is, it might be that an independent judge comes to exactly the same decision, but it's about the quality and the nature of the decision, because that judge is independent of political pressure.
Julian Lewis.
I just want to give you an opportunity to give your assessment of the adequacy or otherwise of the European Convention on Human Rights and the UK Human Rights Act in relation to interception. Now, the interception of the content of communications is permitted only if it's lawful, necessary and proportionate, and by a lawful purpose this means that it has to safeguard national security, including where relating to economic well-being or for the prevention of serious crime. So the first bit of the question is, do you think those are legitimate reasons for allowing interception under those acts? Secondly, necessity is taken to mean that the information being sought can't be obtained by less intrusive means. Do you consider that the doctrine of necessity is a valid safeguard, or are there changes you'd want to see to strengthen that? And finally, proportionality, which means it must be no more intrusive than is justified by the purpose of the investigation, and must consider the impact on the privacy of innocent people, which we've discussed a lot today. Do you consider that that proportionality provision is a sufficient safeguard? And please give your response to and an overall assessment of that.
I'm not a human rights lawyer by any stretch, but I think there's a very interesting report that's come out of the UN today, a special rapporteur on counter-terrorism. And if I may quickly quote from that, they say, merely to assert without particularisation that mass surveillance technology can contribute to the suppression and prosecution of acts of terrorism does not provide an adequate human rights law justification for its use. And there's urgent need for states to revise national laws regulating modern forms of surveillance to ensure that these practices are consistent with international human rights law, which pretty much highlights what Big Brother Watch is thinking on this without being a human rights organisation.
What do other people think?
As a statement of principle and an overriding framework, I think Article 8 of the European Convention, as incorporated by the Human Rights Act, does a very good job of setting out the considerations for when interception should be allowed and how. The problem comes, though, that our more specific piece of legislation under RIPA does not incorporate in its spirit, although it may in its letter, the principles that have been elaborated by the Strasbourg Court in incorporating the Convention. So the fact that under Section 8 and Section 20 of RIPA, external communications, those completely outside of the UK or where one point is out, coming from or to the UK, can be authorised in bulk, means that you're already riding a coach and horses through the principle of necessity and proportionality, and that's where the current problems with RIPA lie. So although it does incorporate the words necessity and proportionality, the specifics of how interception can be authorised do not adequately protect those principles.
Michael,
I think in a sense, leading on from what you just said, the difference between RIPA 8.1 and RIPA 8.4 is that RIPA 8.4 deals with external communications and the threshold is lower. And I just wondered in general whether you had any comments on the differences between 8.1 and 8.4 in that regard. Do you think that the threshold should be the same?
It's extremely problematic. It basically contrary to the very principle of proportionality. Because how can bulk collection of communications data ever be proportionate? if it's not targeted, and targeting and proportionality go hand in hand. One of the main problems, however, with 8.4 is not only that it's in principle untargeted, the definition of external communications under Section 20 is extremely vague. It's become even more vague in the light of the witness statement of Charles Farr earlier this year in the proceedings and before the Investigatory Powers Tribunal, in which he indicated that a Facebook post on a friend's Facebook page is considered to be an external communication. So if I post on a friend's Facebook page and I know that that person has 2 other friends, and both of whom are my friends, that is considered an external post because it's going to a server in Northern California owned by Facebook. Whereas if I send that friend an email, even though the email may be routed outside the United Kingdom, that email will nonetheless be considered an internal communication so long as my friend is within the United Kingdom. It leads to absurd results.
What would be your reactions if, rather than just a blanket net being cast in terms of looking at these communications under RIPA, you were looking under categories of communications? I'll give you 2 examples relating to potential terrorism. We know that Yemen, for instance, is one area where terrorism can spring from. We know at the moment that Iraq and Syria are also areas with ISIL operating there where terrorism could spring from and have an effect here in this country. Now, if those areas were targeted, the communications arising out of those areas were targeted, would that make it more acceptable to you?
Well, it's a narrower form than intercepting everyone's communications, but of course under Section 5, subsection 6 of RIPA, there is of course the additional allowance that you're allowed to intercept any communications, whether internal or external, such as are necessary in order to obtain the information you're looking for. So maybe you're only looking for one particular set of communications between someone in ISIS and someone in London, for the sake of argument. But the technical nature of how external communications interception works means that you cannot access that without intercepting also 100,000 other emails going in the same direction or from the same region. And that to me is a disproportionate interference. It may be justified to seek out that one particular person's email, but if the only way that you can obtain that particular email is by intercepting a million other emails at the same time, then it falls to be disproportionate. However valid the investigation may be, you can't justify, just as you can't justify knocking down 100,000 doors because you want to find one murder suspect.
What are the views of other members of the panel on that?
The original question, about whether RIPA needs to be updated, and I think the specific definitions need to be updated. I think we definitely need to have some definition of geolocation data in there, and I believe there's some issue around subscriber data held by service providers as well, and the distinction between a private but person-to-person communications, external versus internal. I think when RIPA was first created, the idea of 2 British citizens emailing each other, one via Gmail, one via Yahoo, and that being described as an external communication, I believe, was never the intention of the writers of RIPA.
Thank you. Robin Butler?
It's not just the entire overhaul of RIPA that concerns us, certainly. It's also reform of the Investigatory Powers Tribunal, which must, I think, happen also. Currently, I would say that the individual has no redress or remedy beyond the IPT, which is obviously closed, if they feel that they've been unjustly intruded upon. And this seems to me a very untransparent and unjust way of doing things, and in fact there needs to be an overhaul not just of the legislation but also reform of the IPT.
Thank you. Robin?
You haven't mentioned the borderline between communications data and content. Do you think that RIPA also needs to be updated to draw that distinction more clearly?
Yes, the distinction I think was can be best sort of explained and was more credible in the age of postal communications, when the communications data was the address on the front of an envelope and the content was the letter inside. But in the internet age, the distinction no longer stands up, particularly given our current levels of use of the internet and electronic telecommunication, etc. So communications data can build up as intimate a picture of somebody's life, their thoughts, their habits, their friendships, where they go, their medical record, their political affiliations, their sexuality. It can build up just as intimate a picture as reading the content of their email or the content of their letter. And RIPA does not recognise this in all sorts of ways, not least that the acquisition of communications data does not require individual suspicion, does not require anything like the kind of authorization that an individual interception in the UK does.
Would you go as far as to say that communications data needs the same protection as content? In other words, that it needs to be warranted?
Yes, we believe that all the intrusive techniques permitted by RIPA need it to be individually warranted, and that must be a role exercised by the independent judiciary.
Thank you. We have less than 10 minutes left, and we'd like to have your views on both oversight and transparency. Let's start with oversight. George?
These sorts of activities by the agencies are involving, in the first instance, ministers either through tasking or, we've already discussed, warrants. They're then reviewed and audited by judges. And finally, if there is a complaint, it's heard by a special tribunal of judges. I think we know that all four witnesses don't think ministers are the right people to sign warrants. So we don't need to go into that again. But in those three stages, how do you think the system needs to be changed?
Well, the current system of oversight for interception and access to communications data is conducted by the Interception of Communications Commissioner. He gave evidence to the Home Affairs Committee that in 2012 he looked at 5% of interception warrants. And most recently, 2013, he looked at under 25% of interception warrants, which I think really is the high watermark. It's never been suggested that any interception commissioner has looked at more than a quarter of the interception warrants made in any particular year. Now imagine if a judge had said that they didn't actually look at 3/4 of the applications for search warrants. Imagine the outcry that we would have in this country. But yet we have a system of oversight that maybe as few as 1 in 20 warrants which are made by a Secretary of State are not looked at by anyone who is independent or impartial. And I think that is simply not an adequate system. I don't mean to criticise that the Interception Commissioner is not diligent and conscientious, and of course a retired Court of Appeal judge. And there has been, I think, a substantial improvement in the quality of his annual reporting over the last 2 to 3 years. But it's plain that he simply doesn't have the time and the resources. I mean, it's not he doesn't even work full time, for example. He doesn't have the time and the resources to look at all the interception warrants that are made. Somewhere in the region of 2,500 interception warrants, somewhere in the region of 500,000 authorizations to access communications data, and he has 9 inspectors to help him look at authorizations for communications data. But even they don't look at more than 10%. So it's a highly unsatisfactory system of oversight from the get-go.
I think resource is very important, but I think also he made it very clear in his report this year, the Commission made it very clear that the transparent information that he believes should be, certainly in his domain, if not the public domain, simply isn't being recorded yet. So the number of individuals that are put under surveillance, the types of offences, we see that frequently within the United States, and that's all on public record. Yet it's not in this country, and I think until we start getting into that habit, in this, having that leads into the problems with oversight and lack of redress as well.
So you're basically advocating something like FISA courts in this country, is it?
Well, FISA court is a prior authorization procedure for the most part. And I think you can look at the way in which oversight, which is after the fact, works hand in hand with prior authorization. There's an argument to be said that if you have a lot of judges or a pool of judges authorizing all warrants up front, then perhaps a system where not every warrant is necessarily inspected after the fact is all right. There's a lot to be said for the judge who authorises a warrant continuing to have oversight as time goes on. It's a very common system under, for example, Title III interceptions under the United States model.
And it's the pre-judicial authorisation that is so important. It's, in to certain regards, not much use to the person whose privacy may have been hugely infringed if all they have is a declaration after the fact by the IPT. Not that it very often happens, that has taken place. In every, Eric gives the example of search warrants. In every other area where the state is able to infringe on privacy in this way, you have pre-judicial authorisation. it's most definitely the case that you can glean just as much information from somebody by bugging, by intercepting, by acquiring their communications data as you can by searching their premises. So why not have an equivalent form of protection?
Right. So one final point then. Your belief then presumably would be that in every, rather than a sample of the warrants that are executed, the Commissioner's role should be to examine every one of them after the event.
Certainly in a situation where you don't have prior authorization by a judge, every single warrant and authorization has to be looked at by a judge after the fact. That seems to me basic. I agree completely. Really, the real issue is prior authorization. If you have prior authorization and continued oversight by the individual judge, then perhaps it's more acceptable to have a situation of more general oversight looking at the policies and procedures and so on. Just a further point about the Investigatory Powers Tribunal. In the first 10 years of its operation, it upheld 10 complaints, 5 of which were from the same members of the same family.
And concerned a local authority that had already admitted to the surveillance undertaken.
Yes, and I think the point that if you aren't notified that you have been the subject of an intrusive surveillance operation, why would you bother taking a complaint? By contrast, a lot of people, who convinced that that they're being constantly spied on by MI5, write a lot of complaints to the Investigatory Powers Tribunal. So, as far as the Investigatory Powers Tribunal is concerned, everything's fine because they get to receive a lot of complaints from people who are, writing in green ink, and so that therefore that they can dismiss most of the complaints and uphold a very small number. It doesn't give you an accurate picture of whether, in fact, most of the surveillance warrants and most of the authorizations which are made in this country are compatible with necessary and proportionate principles identified by the European Court of Human Rights. Because most of those have never been made subject of a complaint.
Thank you very much. We've only got a couple of minutes left. I want to have an opportunity for the committee to hear your views on transparency. Robin.
We all agree that there has, I think, to be an element of secrecy on the part of the agencies and the police, but there's also a general feeling there should be more transparency. Could you give what specific suggestions you've got about areas in which you believe there should be more transparency?
Yes, certainly in relation to the IPT, there should be an appellate layer or upper tribunal in relation to that, as we've just heard the examples previously. It's largely ineffectual, unjust, any word you wish to choose in relation to how it's currently operating. It doesn't seem to me to be effective, so I think it needs reform, scrutiny, and an upper tribunal to appeal matters to, so that individuals can have some form of redress or even response or answer to why they have been intruded upon.
Thank you. Others?
We absolutely agree with that, and would add that the IPT could be reformed to allow oral hearings unless there is a pressing reason for oral hearings not to be allowed, for complainants to be notified when a hearing is taking place, which doesn't currently routinely happen. And for reasons to be given when a finding goes against a complainant. At the moment, a complainant is just told, no, your claim has not been accepted. We also think transparency could be aided by having those who have been subjected to surveillance but are no longer notified after the fact, so that they may be able to challenge whether or not the surveillance was justified, necessary and proportionate, which is, I think, what Dr. Metcalfe was just getting at. But more broadly on the transparency point, we, of course, accept that much of the work of the security services and indeed their capabilities need to be secret, and there needs to be a high degree of confidentiality. The service couldn't operate if that wasn't the case. What we object to is the notion that a mass expansion in scale of, for example, interception bulk data is a capability. It's actually a huge shift in the nature of the work that the agencies undertake. So the idea that this is just a new capability, a new technological device, of course, the public can't know about it, we think is fundamentally flawed as a premise. But what we would also say is that the emphasis has to be much more on checks and balances rather than greater transparency. If you have sufficient checks and balances in place of the type that we've just described, that public trust and confidence can be enhanced, and we can know institutionally that oversight is taking place as it should, and that reduces the concerns that give rise to the need for greater transparency.
Thank you.
Thank you very, very much. We sadly have run out of time. Can I, on behalf of the committee, thank you for your evidence. You've been very clear, you've been very, very helpful, very positive in your comments, and it will be a very important contribution to the work that we do. Thank you very much. If there are any further comments you wish to make, obviously we will be happy to hear from you in due course. Thank you very, very much indeed. Order, order.
Portcullis House, the Boothroyd Room. 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 Portcullis House, the Boothroyd Room.